Okay, ladies and gentlemen, I'm going to go ahead and get us started so we don't lose a moment of our precious time today. My name is Lisa Schultz. I'm a professor here at the School of Law. I'm the co-director of the Terence J. Murphy Institute for Catholic Thought, Law, and Public Policy. We are a joint venture of the Law School and the Center for Catholic Studies, and on behalf of my co-director, Billy Junker, from the College of Arts and Sciences, and myself, I want to welcome you to the Law School, to this panel. This is obviously a moving target. What we're talking about is something that is ripped from the headlines. It's part of our Hot Topics Cool Talk series, although it's following a little different format because we have too much to say about it to fit it into one lunch hour. I want to welcome the people who are watching this video. We got a lot of interest from people who couldn't attend physically, who want to make sure that this is going to be on video, and it will be on video. There are obviously 112 different kinds of perspectives we could take on this topic right now. And we are not going to be able to cover all of the perspectives and give all of the viewpoints and even take all of the different disciplinary cuts at this issue that we would like to be able to offer you. Instead, what we were really excited about doing is providing you a sense of the thinking on these issues from the experts that we are so lucky to have right here in our law school and in our university. And so what I'm going to do is really briefly introduce our five panelists for today, each of whom are going to speak for 12 minutes. After they speak, we are going to give them a chance to respond or talk to each other, and then we're going to open it up to questions from you. We have a couple of students and even our intern visiting here from the United Nations today who are going to be wandering up and down the halls as the program progresses and gathering your questions. I'll then moderate them to make sure that we can get all the questions in the short time that we have. So if you have questions as the debate, the conversation proceeds, just put your hand up and a student will eventually come and take it from you. At any time that you feel inspired, you can do that. Are the question sheets there? They're all sitting there, so you've all got them. Great. So let me just go ahead and in the order in which they are going to speak, let me introduce our panelists. We're going to start with Professor Joel Nichols, who is Associate Dean for Academic Affairs and Professor. He's also Senior Fellow at the Center for Study of Law and Religion at Emory University. He is a scholar of international law and religion, especially family law, First Amendment law, and human rights, and is active internationally in the human rights community. He's going to be giving us general overview and starting to examine the issue of the legality of the use of the executive orders. Next, we'll hear from Professor Tom Berg, James L. Oberstar Professor of Law and Public Policy, former co-director of the Murphy Institute. He is a national and international expert in con law, law and religion. He is the innovative director and creator of our Religious Liberty Appellate Clinic and a leading scholar of law and religion. He's going to be giving us an analysis from the religious liberty perspective. Then we have Professor Rob Kahn, teaches lawyering skills, Islam and civil liberties, and privacy law. He does scholarship in Holocaust denial and hate speech and the defamation of religions. And he's going to be providing us with a little bit of a historical context on the use of executive orders in similar type of situations. Those are the academics, and we're going to move into the academic practitioner, real world people here on this side, coincidentally, of the podium. First, we'll hear from Sarah Gross-Mettner. She's been the general counsel of the University of St. Thomas for 6 years now, and she came to us after a couple of years as managing director and international general counsel of Piper Jaffray Company. She is dealing with and will provide us the perspective of a Catholic university dealing with these executive orders right now, both with respect to students and with respect to employees. And finally, we're going to end with Virgil Wiebe, Robbins Kaplan Director of Clinical Education and Professor, founder of our amazing and groundbreaking interdisciplinary, interprofessional center for counseling and legal services. He is an international activist in a lot of areas on things like landmines and cluster bombing. He teaches and engages in scholarship on immigration law and is going to be providing us the perspective of what it's looking like on the ground from the perspective of the immigrant community that he represents. So with no other further ado, let me introduce and welcome our first speaker, Professor Nichols, to the podium.
Hi, thanks for all of you for being here. I am happy to start off. I'm going to give a little bit of a higher level overview, just looking back at mainly the January 27th executive order, and looking a little bit at a couple of the prominent court cases that have happened as a way to frame this. I'll try to keep it kind of short, maybe shorter than my allotted time even. We can come back and ask some questions, but hopefully this will set it up just a little bit. So a month ago today, President Trump signed an executive order. A couple of highlights, which will come back in a minute. It bars all refugees of any sort for 120 days from the date of the order. Syrian refugees, specifically named in the order, indefinitely. And this severely restricts immigration from 7 countries for 90 days. So there's some different components to this order. It also, this is not talked about as much, but it sets a limit on the total number of refugees even after they're admitted again, dramatically reducing that number. Compare the number in 2016 was 85,000. This number does fluctuate from year to year. President Obama, when he had been in office, set a target of 115,000 refugees granted entry in 2017. So that was to be changed. There's a provision that prioritizes future refugees based on religious minority status, and that becomes controversial in the law. Professor Berg will talk about that more in a moment. And this is currently being stayed by the courts. For any non-lawyers in the audience, this means it's stopped, right? So we'll have a couple of legal terms here that will play out in a minute and give a little more context too. We had thought, preparing the panel, that we might be talking about a brand new order today. President Trump had indicated, and it even represented to the Ninth Circuit, that there'd be another order forthcoming the week of February 19th. That hasn't happened yet. The latest report I saw today said March 1st, this coming Wednesday, Ash Wednesday as it turns out. But we'll see. We'll see. So right now, what does this mean? It means, it's funny, it doesn't mean that there are no rules in place. What it means is that executive order can't be operative. So it seems that we revert to the old rules that were in place. Refugees are still interviewed. It takes a 2-year process, basically, under the U.S. system. There's still a lot of questioning at the border. All of that's still permitted. There's some question about how much this has already been amped up. So news reports just today, the Washington Post has a big story about Mem Fox, an Australian children's author. Many of you have her Time for Bed book. She was detained and questioned for 2 hours as she was headed to a conference to speak in Wisconsin. Other people, Klaus Lang, an Austrian composer, denied a visa coming in. It's not clear why. He kind of thinks it's because he had visited Iran at one point. But again, so stories are still bubbling up even without the order in place. The order itself, right, without walking through kind of all of it in a legalistic manner, it starts by relying on September 11th, right from the outset in Section 1 as its purpose, despite the fact that none of the countries that were targeted were, as a country matter, implicated by their citizens in 9/11. It relies specifically on this statute, 8 U.S.C. 1182F. I gave you a little bit of the language here. By proclamation and for such period as the president shall deem necessary, the president may suspend entry of all aliens or any class or impose on them any restrictions he may deem to be appropriate. This is a 1952 statute. The language is passed by Congress. It's really broad, right? This is broad language. It's been, in many other circumstances, upheld. Maybe Professor Wiebe can kind of speak to some of those if he looks back at other cases. But this is pretty broad language. It's not clear what the legal boundaries are. It certainly is the case at the far extreme, however one interprets it, that the president doesn't have the right by congressional statute to violate the Constitution. How that plays out in specific cases is an open matter. There's some question whether this statute conflicts with a later law that bars discrimination in the issuance of an immigrant visa because of race, sex, nationality, place of birth, place of residence, and the like. Some have argued that that overtakes it. It hasn't been played out. Religion's not explicitly mentioned in that 1965 statute. So we'll question as well what other boundaries might exist. Does the Establishment Clause of the First Amendment come into play? Does it have any traction for people that want to enter the United States, or may the government rely on it for other purposes? These other last couple of points are things that I've mostly mentioned before. There's the list of countries. Note that it can be expanded by the terms of the order itself, and we'll move on. Okay. There was a lot of things coming out of this, and pretty quickly there was a lot of litigation. So the evening, Saturday, after the order was issued, there was a lot of buzz because it had supposedly been stopped, been stayed. That wasn't really the case. There were a bunch of lawsuits. You saw the lawyers in the airports bringing these lawsuits on behalf of people. But what happens is the courts appropriately are going to try to limit their review to the narrowest issue possible, to the people right in front of them, to get more information. So there was this funny mix of things happening really fast, but not very fast. And that's what happens kind of in these matters. The most talked about case is the Washington case. I'll give more on it in a minute. It was brought by Washington on January 30th, subsequently joined by the state of Minnesota. Heard at the federal district court level February 3rd. So again, this is a very fast time frame. And the level for this is, think about that you've got 3 different periods of time that a court will hear things. The first is a temporary restraining order, a TRO. This is effectively almost an emergency action. In the most egregious cases, it can be brought kind of immediately. You get very little hearing. It's possible under the rules and the right kind of case for this to be one-sided. It's called an ex parte TRO. That's not what happened here, but this is a spot where a court can move quickly without all of the evidence. The next step is a preliminary injunction. There you're going to have more briefing. You're going to have evidence brought before. It's still not final hearing on everything, but it can happen faster, maybe a couple of months. Then you move down to a final determination. Sometimes, if it ends up being stopped, we'll call it a permanent injunction. Although permanent injunctions, that's not a definition of a time period. It can be a permanent injunction, could last a year and a half, 2 years. Permanent simply means a final decision on the lawsuit. It's got all the evidence in hand. So this is the TRO. It's the fastest, the least amount of evidence. The judge had briefing, but then had a hearing that afternoon, Judge Robart did, and then issued an order February 3rd. So that's fast. And somewhat controversially, this is a nationwide injunction. So some of the earlier cases, there's 5 other cases happening, they're limited to the parties in front of them, or maybe limited to their specific state or their jurisdiction. This case said this applies everywhere because immigration law, among other things, affects everyone across the nation, so we should do it that way. That itself is controversial. It worked against the former administration, a nationwide injunction in the Texas case, again, regarding immigration. Here it works against the current administration. The Ninth Circuit didn't, this is interesting, didn't stop the emergency stoppage, basically. So they didn't stay the stay, we would say. But they got hearings on this, and in their order that came out on this, they kind of transformed this temporary restraining order into a preliminary injunction. Technically, a TRO is not an appealable order. The next thing after what happens is once a TRO is issued against you, you go to get a preliminary injunction. Or you fight it out, but you stay before the judge who issues the TRO. In this case, it went up seeking an emergency stay, and the court deemed it admissible, basically. It could have just said, we're not going to talk about the case. But so then it kind of transformed it into a preliminary injunction. That creates some weird procedural things we could talk about later if we want. But it also means the court was looking a little more closely at the evidence than you usually would have it at a TRO stage. And so even the standard of review, it reads a little bit funny in that sense. My take, just for what it's worth, is that there wasn't very much legal analysis at the TRO stage, right? There was a lot of talk in that 6-7 page order about the standard. The analysis was really quite thin. It's not totally unusual for a TRO, but here it left a lot to be desired. That wasn't the case at the Ninth Circuit stage. It was a long, very full order. There's another case since then, February 13th, about unrefuted evidence about the Establishment Clause. Sean's already showing me signs, so I'm going to go faster through these couple of slides, but I've got a couple of questions at the end that I'll pose, the other panelists can answer, or we can talk about at the back end. I mentioned already about TROs. Several questions in here as you think about this Ninth Circuit case especially. One question is, should the states have the ability to sue, or should we be relying on individuals for this? So we're relying especially on universities and their interests, so I'm glad Sarah's here to talk about that. The government claimed effectively unreviewable authority, at least according to the court's opinion. The court's going to disagree with that every single time. I don't care what executive it is, that's a bad claim to make. The legal standard on appeal, note this, because of the posture of the case, the government had to overcome the burden on appeal. So don't overread the Ninth Circuit's case, because the government had to do more in this case to win. Perhaps on a full hearing, the burden certainly will be shifted. The government won't have to prove as much. That might change things later on. The opinion itself relies heavily on due process, right, where the Fifth Amendment says the government can't deprive individuals of life, liberty, or property without due process of law. And this extends to legal permanent residence. White House counsel said, oh, we kind of retracted that. Those are green card holders. The court said, well, just retracting it doesn't really mean you retracted it. That's not binding, so we're still going to pass judgment on that. The court hinted it might apply to other categories visa holders, but it didn't rule on that as explicitly. And the court refused to rewrite the order. The attorneys invited it to limit it down. The court said, we're not going to do that. That's not our job. You get it right. It discussed but didn't rule out religious discrimination claims, and it wanted more information on national security. A couple of things to think about as we end. Sean holds up the stop sign, and I'm doing pretty well. Right? What do we do with the next executive order? Does it automatically supersede the old one? The administration has hinted it's going to leave them both on the books. That's a bad legal move because you have a court order against one of them, and it would give the court more incentive to say, I'm not going to drop this case. Remember, we're at an early stage. Why would I drop the early case if I'm the court and deem it moot if the government keeps asserting the same kinds of governmental powers and says, I'm not even going to withdraw a thing? So we'll keep our eye on that. Okay, I'll stop at that and then hand off to Tom Berg.
Okay, thanks, Joel. I am going to talk about the religion issues in this order. And I should say that the Ninth Circuit opinion, the most prominent one, does not, as Joel said, does not rule on the religious discrimination issues on the so-called Muslim ban. It suggests that there are serious issues here, but it doesn't rule on it. And I'm going to try to suggest that there are serious issues, but that it's also a complex issue. Muslim ban is too simplistic, but there are serious issues with the religious aspect of the order. So, and we'll be talking about primarily the first order, the existing order. We're kind of talking the whole day here about a specter hanging over the room of another order coming out, which we don't know exactly what it will say. But let's talk about what's in the existing order, because I think those are interesting issues. All right, so again, to repeat what Joel said, there are two parts, relevant parts to the first order with respect to the ban on the effect on Muslims. There's the ban on travel for 90 days from the 7 nations, which are all overwhelmingly Muslim majority nations, 90% or more. So that part of the order clearly is going to affect primarily Muslims. The other part is the suspension of the refugee program for 120 days. And that's from all nations, not just the 7, which is an important point to emphasize. Now, that suspension of the refugee program, 120 days, also contains a couple of qualifiers that are essentially preferences for minority religions. 2 kinds of preferences for refugee claims brought on the basis of religious persecution, which is one of, is it 6 grounds for persecution? 5 grounds for claiming persecution.
Because I run out of fingers.
Yeah, okay, right. But there are preferences in the order for religious persecution claims going forward when the individual making the claim, seeking refugee status, is a religious minority in his country of nationality. And that happens both during the 120 days. There's room for case-by-case exceptions to the refugee suspension. An individual can claim a sort of special circumstances. And in that situation, one of the things that the ICE is supposed to consider is whether this person is a religious minority. That's one factor. So it's a kind of preference, not an absolute right, but a kind of help to those who are religious minorities in their home countries. After 120 days, if and when the program, the general refugee program, restarts, there will be a prioritization, the order says, of religious persecution claims, provided that as long as the individual making the claim is from a religious minority in his home country. And that prioritization could matter a lot because, as Joel said, the number of refugees allowed is going to drop substantially under the order. So priority could really matter. It might not just be you're first in line. It might be, you have a much higher chance of getting in. These preferences are likely to disfavor Muslims statistically. It's a little complex, but they are likely to. I could run the numbers. I've been working with my student in the Religious Liberty Clinic, Jessica Lanzi, and we've sort of developed numbers on the likelihood of this. But basically, a larger percentage of refugees who are Christians are minorities in their home country than the percentage of Muslim refugees who are minorities in their home country, right? So to emphasize the protection of minority religions is going to have a disproportionate effect in benefiting Christian refugees and not Muslims. But there are definitely Muslim minority refugees, some very substantial cases. The most obvious one is the Rohingya group in Myanmar, people who have come over from Bangladesh and other areas who are Muslims, and they're treated horribly by the Myanmar government, and they are a significant refugee group coming to the United States. They would be benefited by this minority religions preference. It may well be that within any Muslim majority country, Shias, who are minorities as against a Sunni Muslim majority, would count as religious minorities. The order is not clear on that, but that's basically been the practice of the State Department in the past, and vice versa, Sunni minorities in a Shia country like Iran. Okay, the claim here is that this is a Muslim ban based on the these disproportionate effects plus an intent, a motive to disfavor Muslims. Now, as Joel said, making a claim of unreviewable authority is the government runs up against real problems doing that. If this order said Muslims are banned from coming into the United States, it would almost certainly, despite whatever discretion the government has in the area of immigration, it would be, the court would find a way to strike that down. But it doesn't say that. Instead, what the challengers have argued is motive on the part of President Trump. And there are two aspects of that. With respect to the overall ban on the 7 countries, the challengers to the order point to the president's statement back in December of 2015 calling for a total and complete shutdown of Muslims entering the United States. Okay, that was done in December 2015. I'll give you a second here to look at it on the board. You can see it. I don't know if it may not be that easy to read, but Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on.
I think there was another word in there.
Not on this statement, but maybe in person. It might have been 2 words, right? Was it? So at any rate, that's the background, right? And that statement is still on the website. It was taken down from the president's website for a couple of days around the election, and then was put back up. So it's still up there on the website. You may have heard Rudy Giuliani, advisor to President Trump, quoted as saying, the president first wanted a Muslim ban, and then he came to me and said, show me the right way to do it legally. And the challengers, the state of Washington and others, are saying this indicates that the whole goal here is to continue a kind of ban on Muslims, just figure out a way to cover it up with language. You might or might not read that statement by Giuliani that way. There are possibly other ways to read it. Do something legal rather than something illegal. But that's certainly among the evidence that the challengers are relying on. But of course, the ultimate order is not a complete shutdown. It lists, it leaves, I believe the number is about 88% of the Muslims in the world are in countries who can still continue to come to the United States. So it's far from a complete shutdown. And it lists by nations rather than by religion. Does that change break the connection with the earlier, rather clearly anti-Muslim statements of the president? And does it effectively change the intent? Are we talking about, well, there was an earlier bad intent, but then the president, was told by people that you can't do that, you've got to do something else, and that's what he did. Or, on the other hand, can you infer that the original hostile attitude reflected in the statement back in December of 2015, that we got to just keep all Muslims out for a while, who cares what the effect of that will be? Can you infer that that continued to motivate the adoption of this narrower order? That's the kind of thing that the courts will be looking at if and when they really consider this issue fully. So there's the first set of evidence of motive. The second has to do with the refugee provisions, and there is here the primary evidence of a discriminatory motive against Muslims is a statement by President Trump in an interview that persecuted Christians would be a priority under the order. This is an interview with the Christian Broadcasting Network in January, around the time that the order came out. There's the headline. President Trump says persecuted Christians will be given priority as refugees. You should know that headlines, a court's not going to rely on the headline of an article. But what does he say? David Brody, the correspondent, asks him, as it relates to persecuted Christians, do you see them as kind of a priority here? And Trump says yes. The president says yes, or the president-elect. I guess he was the president at that point. Christians have been horribly treated in the past, and they've been treated unfairly. He said they hadn't been allowed into the country with the same kind of stand. They've been discriminated against in the past and being led into the country, he was suggesting, and so we're going to help them, he says. Okay, so there are the two kinds of intent, or the two kinds of evidence of intent or motive. There are two kinds of legal claims that these go to. I'll run through these very quickly. One One is, as Joel mentioned, the Establishment Clause of the First Amendment, which, among other things, prohibits favoritism for one religion over another. In this case, the claim is favoring Christianity over Islam in the refugee provisions. The second claim is that under the Equal Protection Clause of the Constitution, even a facially neutral law that doesn't mention Muslims on the face of it, that disproportionately hurts one religion and is intended to do so, can be struck down under the Constitution. That is, motive matters, according to the challengers. If it was adopted for that motive and has that effect. I can tell you a little bit about some of the cases later on, but if you want to hear more about it, but there are cases that support that idea. The third ground that the challengers are using, and this is an interesting one, is the Religious Freedom Restoration Act of 1993, a federal statute that you may have heard of before because it was the statute involved in the famous Hobby Lobby case. Now, liberals tended to come to hate the Religious Freedom Restoration Act after Hobby Lobby because it was used by corporations, their family-owned businesses, to resist paying for contraception for female employees. Now liberals have suddenly discovered that RFRA is really not that bad a statute, and it's being used to protect Muslims. I'll tell you my own bias on this as a religious liberty lawyer, as an advocate for religious liberty, as well as a scholar. I like to see strong religious liberty protected strongly for all groups, and so I'm glad to see RFRA rehabilitated a little bit. There are differences in the two cases. Obviously, religious liberty comes up in different contexts, but generally strong protection for religious liberty is a central part of our tradition as Americans, protection both for people here and this place is a haven for people coming here. And we are we're going down a bad road if we lose that sort of tradition, whether it's for conservative reasons or for liberal reasons. The last question then that I'll talk about here briefly is, does this evidence of motive count? Because the government says, don't start looking at President Trump's tweets and the statements on his website. That's going down a very bad road, the government says. Don't look behind the face of the order. There's some cases that support that idea. Courts shouldn't start looking at officials' often exaggerated campaign claims or public claims, right? You need to focus on what the order does. The ultimate order rejected a Muslim, sort of total Muslim ban. It's only 7 nations, and it favors all religious minorities. On the other hand, the challengers say, well, there are these other precedents that say a bad motive can invalidate a policy that has an effect on a discriminatory effect on a group. And we're now talking here not about the motive of a legislature based on one legislator's statements. There are real problems with doing that. How do you know that any one legislator speaks for the whole body? But President Trump speaks for himself. And so to look at the president's intent in issuing an executive order may be easier to do. And finally, an important case, interesting case about a Ten Commandments display that I can explain a little more that may suggest that you can look back at the history of a policy. Here's, I think, the sort of probably the most important question to the extent the courts get to the merits of these claims. And that is, President Trump has been particularly explicit in the past in stating a willingness to exclude Muslims. Now, maybe the ultimate order does that only in a disproportionate way, not an absolute way. But in the past, he's been willing to be explicit about a flat-out ban. That's a really unusual thing. Newsflash, this presidency is unusual. Will that affect the court's attitude? Right? They're generally reluctant to look at intent, the fuzziness of intent behind a facially neutral policy. But maybe they're more willing to do so here when the president has been so explicit and in some ways over the top in some of his statements. I'll leave it there, and there are plenty of other things that we could talk about. Thanks.
that's fine. Hello, thanks for having me. In my day job, I teach legal research and writing, and one of the things that I looked at the day the executive order was passed was Korematsu v. United States, and I discovered that it had an orange treatment flag, which means that Korematsu is still good law. And what I would like to do today in my 12 minutes is look at the historical parallels between the executive order banning people from 7 countries and the internment of Japanese Americans during World War II. And to kind of highlight 2 main points that got me interested in this and were troubling about the travel ban immediately. The first is that it is banning people based on national order, which could be a cover for religion or, talking sociologically rather than legally, ethnicity, that 5 or 6, depending on how you look at the countries, have large Arab populations. The second point is that it doesn't seem to be related to a specific threat or a specific threat other than random events after 9/11. And in my talk, I want to focus on 3 themes: fear, namely the possibility that the executive order represents a fear of bad things happening; hate. If the executive order isn't based on fear, what might it be based on? And then hope. Given the current realities, are there things that one can draw from Korematsu that might be positive and give you some general hope for the future? So let me start with the general background. And I'll begin with a quote from Mr. Justice Black upholding the majority in Korematsu. And Justice Black said towards the end of his opinion, Korematsu was not excluded because of hostility to him or his race. He was excluded because we are at war with the Japanese Empire and because the properly constituted military authorities feared an invasion of our West Coast. So to just give a little background, in December of 1941, the United States entered World War II after Japan bombed Pearl Harbor, sinking a large chunk of the West Coast fleet. In February 1942, Lieutenant Commander DeWitt took control of the West Coast. Between March and May, he passed a series of executive orders, beginning with a curfew, then an exclusion of people from the West Coast named Military Regions 1 and 2, and then finally a plan for assembly and internment of Japanese Americans to camps. There were about 120 to 140,000 people who were interned. In December 1944, just as the Battle of the Bulge was raging, last gasp of Hitler's empire, the United States United States Supreme Court in a 6-3 vote upheld the conviction of Korematsu for violating the exclusion rules. So they never reached the question of the internment itself, but said that he had remained in California after he was told to leave. Korematsu itself has somewhat of a mixed reputation. I mentioned the treatment flag. Chief Justice Rehnquist, in his book, All Laws But One, Civil Liberties in Wartime, was somewhat sympathetic to the Justice Black's opinion. On the other hand, we've apologized to Fred Korematsu. His decision has been vacated. We've made reparations to Japanese Americans, and in 2011, I believe, Obama's Solicitor General admitted error in the case. So why? Why the change? And here there are some echoes to what Professor Berg has mentioned about types of evidence that suggests a bias. So if you recall, Justice Black's colorblind approach of this is not hostility based on race, there are 2 types of arguments you could make to suggest that it was different. An indirect, circumstantial type of evidence, and then evidence of motive. So let's talk about the indirect evidence. The official motivation behind the orders was a fear that Japanese Americans, out of loyalty to the Empire of Japan, would commit acts of sabotage or disloyalty, and that the government couldn't find out who was involved. In actual fact, there were very few acts of sabotage and disloyalty, and the government, by and large, knew the small group of people who were doing it. Then there were arguments about who the United States government did and didn't round up. We didn't, in an en masse sort of way, round up Germans or Italians, nor, for that matter, did we round up Japanese present on Hawaii, where they were a large percentage of the population. So that leads to some suspiciousness, somewhat similar to the way in the executive order we have not, it does not apply to Saudi Arabia, where 19 out of the 29/11 attackers come from. The second theme I want to bring up is, again, direct evidence, explicit racism. And here I'm going to quote from Justice Frank Murphy's dissenting opinion in Korematsu. It's very stirringly written, but rereading it after this event, I'm even more impressed by the footnotes in the research. He did an amazing job in coming up with evidence of, or poking holes in the evidence against, or what he calls the bogus sociology, that would try to cast all of Japanese Americans as a threat. So here is Lieutenant Commander DeWitt testifying before a House Naval Affairs Subcommittee. I don't want any of them here. They're a dangerous element. There is no way to determine their loyalty. This isn't that different from anti-Japanese sentiment in California. Here is Justice Murphy quoting Mr. Austin E. Anson, Managing Secretary of the Salinas Vegetable Growers and Shippers Association. We're charged with wanting to get rid of the blanks for selfish reasons. We do. It's a question of whether the white man lives on the Pacific coast or the brown man. From this, Justice Murphy concluded, inferring group disloyalty from individual loyalty denies that under our system, individual guilt should be the sole basis for the deprivation of rights. To do so, he went on, is to adopt one of the cruelest rationales used by our enemies to destroy the dignity of the individual and to encourage and open the door to discriminatory actions against other minority groups in the passions of tomorrow. And here you can again make some similarities with the executive order in that there is no evidence of threat, and there seems to be an assumption in the statements that Trump has said both in the campaign and as president that the concern is with Muslims and Islamic terrorism. He wants to rename the Combating Violent Extremism program, Combating Islamic Extremism. I don't know the exact name, but it is that type of thing. And I would say, you know, words have consequences here. You have the questioning of Muhammad Ali Jr. by ICE or Border Patrol agents when he came into the United States. It is something concerning, and to the extent Korematsu was based and is now repudiated today as being based on an assumption that one member of a group is the same as any other member of the group, so basically racism and a lack of threat, you can make a similar argument about what's going on with the executive order today. But I want to suggest our situation is even worse than that, because if you look at the internment orders, they were 3 to 6 months after Pearl Harbor. This was before the Battle of Midway, which ended any chance of Japan winning the Second World War, if that was ever a possibility, and before Stalingrad, where you could say the same thing about the Axis powers more generally. The specific threat in Korematsu may be lacking, but there was a context, a real context. Contrast this to Trump's executive order. And here we're kind of shifting from fear to hate. Trump mentions 9/11, but nothing else. Indeed, after 9/11, there were discussions about what Korematsu meant for the emerging war on terror and some of the actions taken immediately after that. The Patriot Act, some of George W. Bush's immigration policy at the time. But the trigger for the executive order wasn't the day that will live in infamy. It was the day that Trump was inaugurated. And that is troubling. It's troubling particularly as a Jew. As someone who was born 18 years after the end of the Second World War, I find this scary, in part because when I look at things that motivated the Holocaust, I think about claims of Jewish criminality, Jewish control over the media, and I listen to what Trump and his supporters say about Muslims, and I feel like there are some similarities here. And in thinking about this, and I will probably get into trouble for saying this, but here goes. The Holocaust didn't begin with killing Jews. The Holocaust, and there's a lot of literature that in order to have this type of mass killing, you need to have a triggering event like a war. But the Holocaust began, or the Nazi Party program began with the idea of making Germany Judenrein, free of Jews. They had different ways of thinking about doing it. The SS St. Louis is an effort in 1938 and 1939 for Nazi Germany to get rid of 900 Jews. For a while, there was the Madagascar plan. The final solution is called final for a reason. That's going to be the end of what I say as well, so we can take up more of this.
What an excellent segue. That's great. So I'm going to talk a little bit from the theoretical. That was a great transition, actually, from Rob, to how does this actually affect institutions and individuals. Virgil will talk a little bit more about it from the immigrant perspective. I want to talk about it from the institutional perspective. So the executive orders are very important to institutions, both business and higher education. And I'll start with the broader scope of business. I mean, both business and higher education are global enterprises today. It's not just Silicon Valley, it's not just California, where there are lots of people from other countries working and engaged in enterprise. Minnesota is full of foreign nationals who are working for our businesses, working in agriculture, working in service industry. Many of those individuals have visas. They have temporary visas. They're here to work or here to study as students. Or they're green cards, they're permanent residents of the United States. They're not citizens, but they're permanent residents. And we have some individuals and students who are not documented under our immigration system. They're here without appropriate visa documentation. That is not uncommon. You're going to see it all over the place. So it's very important for employers, and particularly important for universities and colleges, where we have a very large proportion of individuals from all over the world. We're trying to get the best qualified people to come here to this enterprise, to be working together as a think tank, as an academic incubator, basically. We're trying to pull all these great minds and great young minds together to educate people and to try and help people really think about how to solve the world's problems. So, of course, we have a lot of people from all over, and one of our big convictions and goals is to have a diverse community here at the institution. So we've got foreign national employees here and in businesses across Minnesota: scientists, engineers, researchers, physicians, professors, visiting scholars. Many of them have families here. Often their families don't have the same legal status as they do, because employees might get a visa for work purposes. their family comes along, maybe the employee gets a permanent residency, the family might not have done that yet. The employee moves along to citizenship, maybe the family member hasn't done that yet. There are different time frames for doing that in practice. So that's important to keep in mind. From a student perspective, we have students who are foreign national students who come from all sorts of other countries, who come on temporary visas, student visas. We have some people who are in the community working as employees, and they come to the university to study. And we have, as I mentioned, undocumented students. So there's no federal law that prohibits universities from accepting students who are undocumented or who don't have appropriate visa status or citizen status, immigrant status. And if a student comes to us and they are trying to obtain that status, there are things that we need to do to help them and track that. But if they apply to the university, we basically consider students for admission without reference to their citizenship status. And it's really not our responsibility as an institution to pay attention to that from a student perspective. It is our responsibility from an employment perspective, and that's something that all universities, I think, pay very careful attention to. But from a student perspective, that is not part of our responsibility. There are a couple of programs that you should know about and that will impact sort of how we talk about the rest of this, which there are two programs, DACA, the Deferred Action for Childhood Arrivals program, which you may have seen about in the news. It's gotten a lot of attention recently since Trump was elected. And then in Minnesota, we also have the Minnesota DREAM Act. The DACA program is basically a program that gives, there's a question about whether or not it's considered lawful status. It's not a path to citizenship, but it basically protects students from being deported for a period of time. And it's for young people who have been in the United States for a period of time and effectively came to the U.S. as children, have been here, have been educated here, were raised in the United States to a large degree. And there's a strong sense of fairness that it would not be fair for those students not to have the opportunity to get an education or to get employment, and that they should have some path to be able to participate in our society. They likely came with their families as kids. They didn't really have a personal choice. It wasn't really, they weren't majority age, so they didn't have agency from that perspective. So that program was in place under the Obama administration. It has continued over till now, but there's a lot of question about whether or not that will continue to be in place. Minnesota also has a program, it has an act called the Minnesota DREAM Act that basically provides that students who are undocumented, if they came as children, have been here a certain amount of time, do a few things like register for the Selective Service, things like that, they are able to get state grant aid and private grant aid in Minnesota if they qualify for this DREAM Act. So it's another way of supporting undocumented students. So we basically have some programs that are acknowledging that there are undocumented students, and certain undocumented students, if they meet these qualifications, they are welcome to be here and to be not just engaged in the higher ed enterprise, but to be working. They can get work authorization to travel abroad, even though they don't have a visa to come back in the country. They actually have a protection that they can go study abroad, and that they can get financial aid in Minnesota. They can't get federal financial aid, but they can get state grant aid, which makes a huge difference for a lot of these students. So that's good background to have. So in this world of higher education in particular, and also the business world, people are traveling all over the place now. It's just very standard. If you're working for a big corporation, chances are you've got some travel if you're in a professional position, because a lot of our corporations, especially in Minnesota, where we have a very high number of Fortune 500 companies, they've got business enterprises all over the world. People are going back and forth. In the higher ed world, we have, as I mentioned, a lot of collaboration going on from an academic enterprise perspective. We have students we want to study abroad, so students are going abroad for a semester or a year. We have academic programs that have components of those programs that are overseas. So we've got students who are going with their faculty to go learn something for their MBA class. We've got students who go with faculty to do field work overseas. We have students who are doing research overseas in other ways. We have people going to academic conferences. This is true of faculty as well as students, of course. They're going off and working and collaborating with people all over the world. So what happens when there is, first of all, an election where the president is very anti-immigrant sentiment is out there. So our first response as universities was to really give warnings to our DACA students and our undocumented students that on Inauguration Day, you need to make sure you are in this country. Because if you're not, we don't know if you're going to get back in. All right? So if you had a student who had DACA status and they were able to study abroad, what if Trump decides on Inauguration Day, I'm not continuing DACA anymore? This is still a question. And we can see with the executive order and how those got implemented and how quickly they got implemented and how much chaos there was around the implementation, that it is very unclear whether or not there would be transition time given if they decide in this administration to stop honoring the DACA program. So we've had to give that advice to our students. So colleges and universities across the country basically have been doing that. For faculty and students who are covered by the executive order, the travel ban countries, of course, there's been the same kind of advice, and colleges and universities were scrambling when those orders came out because there were a lot of people who were overseas. We at St. Thomas don't think we had any issues with that. We didn't hear about any particular individuals who were overseas at the time the order went in place, but I know a lot of other colleges and universities. I was at a conference at the time with general counsel from colleges and universities across the country, and many of them were working with their Office of International Students and Scholars to try and bring people into the country and figuring out where they could fly, students, and you've seen a lot of these articles in the newspaper. Well, that was happening. And our concern still is that we don't know, what's going to happen exactly with the executive order. So if you're from one of those countries and you're here, can you leave? The advice would be no, you can't leave. You shouldn't leave until we know what's going on there. Well, what if I'm not from one of those countries, but I'm from another country that might be subject to higher scrutiny because it's got a large Muslim population? Well, yeah, we don't know about that either. So maybe you need to stay close here and think about how does that then impact, if I'm a student, my study abroad plans, my academic programs that might have this component to it. Even if I have a legal, right to be here under my permanent residence, right? I've got a green card. It says I should be able to come in and out freely. That's not what's necessarily been happening. So there's a lot of uncertainty and anxiety around this, and it really is a limiter on what people can do right now until there's clarity around these orders and what's going to happen going forward. We also recruit heavily internationally because we do want this diverse enterprise. So because of the uncertainty around this, the U.S. is getting kind of a bad rap among prospective students, prospective faculty, prospective staff around the world, right? Would you want to come and study at the University of St. Thomas if you're, from a place that you might get banned later? You might not be able to go or have your family join you. You might get separated from your family. These are problems for all colleges and universities. For Catholic colleges and universities, I think they are particularly significant. And maybe the way to think about this for a Catholic college or university is we have to worry not just about complying with the law, but we also have to worry about complying with Catholic social teaching, which asks us not just is this legal or illegal, but what are we morally compelled to do because of our conscience, right? So the U.S. Conference of Catholic Bishops has been very outspoken about its concern about the executive orders, its support for the DACA program. Similarly, Catholic colleges and universities have expressed very vocally their concerns and their support for DACA, their concerns about the EO and their support for the DACA program, and programs like that, the DREAM Act and a Bridge Act, which would help be clear they would provide clarity for undocumented students about their ability to continue to get higher education. And there is a document I just refer you to, which is Forming Consciences for Faithful Citizenship, which is published by the U.S. Conference of Catholic Bishops. That's a call to political responsibility from the Catholic bishops of the U.S., which is really a great read if you want to think about what are the obligations of Catholics and I would say by, extension, Christians and people to deal with strangers in our country, people who are here either on an authorized basis or an unauthorized basis. Basically, the Catholic Church says we should be welcoming them and we should be treating everybody with human dignity, and that's the foundation for everything we should be doing. And when you look at that and you apply it to how we work as an institution here as a university and how businesses should be working, I think there's a really good argument for why these executive orders don't make sense for us and why we have to be really all caring about them and how they get implemented. Okay.
to admit I forgot this was about the executive order from January 27th. Because I don't care about it anymore. It's old news in the sense that it's been stayed. You know, there's going to be a new order. Some attorneys are going to look at it before it gets issued. They're going to clean it up. They're going to strip out the stuff that's the most problematic, and most of it's going to be upheld. That's my prediction. So I haven't been wasting much time on it of late. I was like rereading the order over there so I'd have something to say about it. So I'm going to say a few things about it, and then I'm going to talk about the other executive orders from January 25th that were implemented last week, a week ago today, and some of the issues that are arising out of that. It's not to say that that we're not concerned about the executive order from January 27th. We've got some clients that have family overseas that may or may not be affected by the order, so we're really strongly encouraging them to get their family members on the plane, and making those arrangements doesn't happen overnight. Okay, I do have some concerns about it. Just a few comments. You know, there's been talk about standing. There's some delicious ironies in this whole business. The Texas v. U.S. Case that was brought by over 20 states to stop the deferred action for parental authority, which really was an extension of the DACA program that Sarah talked about, was stopped on some rather expansive views of standing, including the cost of driver's licenses in Texas. And the Ninth Circuit cited that order for supporting standing in this case for Washington and Minnesota. One of the real questions there, and I think that's what's going to be different about a new order, is who is affected by this. In Washington, there was talk about universities and the cost to states, really looking at students, scholars, and universities. But the tougher question is, what about those people who are outside the United States? And people who are applying for refugee status, maybe they've gone all the way through the process, or perhaps family members of U.S. citizens or legal permanent residents in the United States who've gone all the way through the process, and they're just waiting for that last stamp before they come into the U.S. Those are going to be harder to make arguments for. Arguments will be mounted for them, but those are tougher cases. What I found just breathtaking about the Ninth Circuit decision, going back to the question of, do courts have authority to review decisions involving national security and foreign policy and immigration, was that the Ninth Circuit, in support of its authority to review this order, was citing cases at the core of the plenary power doctrine. And the plenary power doctrine, as I summed it up to a reporter a year ago, much to my chagrin, and now it's going to be recorded again, because I'm going to repeat it, is that the president can do whatever he damn well pleases. Well, Texas v. U.S. proved me wrong. He can't do whatever he wants. But the plenary power doctrine goes a long way towards that. And the Ninth Circuit cited cases, Ex parte Quirin from 1942, which gave a lot of authority to the president to prosecute saboteurs. It cited Ex parte Milligan from the Civil War, which gave the president a lot of authority to do what he wanted, but not unlimited authority. Kleindienst from 1972, the court distinguished that. That was a Cold War case. Cha Chan Ping from 1889, one of the Chinese exclusion cases. The Ninth Circuit cited that case to say the president can't do whatever he wants. That was a case where Congress had passed a law saying no Chinese can come to the United States. And the Supreme Court upheld that It said there was, the Congress is bound by the Constitution. But that involved a guy who had moved here as a resident in 1875. He goes home to visit mom in China in 1887. While he's on the boat coming back, Congress says no Chinese can come in. And the Supreme Court upheld that. And the Ninth Circuit citing that case to say, President Trump can't do this. So, it's just, wow. Anyway, so now I'm going to talk about what I want to talk about, and how many minutes do I have to do that? 18 or 20. All right. So I've got 6 points here. The first point is who's running the show, okay? And I think we need to have that context for who is coming up with these ideas. And this isn't an exclusive list, but it is a list. It is folks from restrictionist think tanks, including the Center for Immigration Studies and the Federation for American Immigration Reform, who have been formulating these plans for many years. And now they've got the playbook, and they're rolling out that playbook. The unions of Immigration and Customs Enforcement and Customs and Border Protection, the Border Patrol Union, they have an enormous influence now on how things are being implemented and enforced. And we need to remember that the Department of Homeland Security is a teenager, all right? It was created in 2003. It was pulling a lot of different institutions together. There's a lot of question about how fundamentally the institution understands the Fourth and Fifth Amendments. It's not as much a criminal law enforcement as a civil law enforcement, so then there are questions about how do those amendments apply in a civil context. But one of the challenges for advocates well before the Trump administration is how are these institutions held accountable? All right, complaints about Border Patrol abuses have fallen on deaf ears. There's a case, I see Professor Sisk nodding, a case in which was heard this week at the Supreme Court about how to hold Border Patrol agents accountable for shooting across the border. It involved a case in which a Border Patrol agent killed someone on the other side of the Mexican border, and there may not be any accountability for that kind of activity. So that first question of sort of who's running the show. And then secondly, looking at these new, the next four I'm going to do real fast, but looking at the implementation of the other executive orders from January 25th. The notion of what does the home mean? I mean, the home in Anglo-American jurisprudence as the castle, how protective is the Fourth and Fifth Amendment? So I'm getting an exercise in this as I go to churches and I explain to people what the Fourth Amendment is, what the Fifth Amendment is. You don't have to say anything. There needs to be a warrant before agents can come into your home. And hearing stories both locally and nationally of how agents are talking about, well, now we can have fun in our jobs. Now we're going to be allowed to enforce the law. So a third point with respect to houses of worship and schools. Going back to the 1990s, there have been memoranda in the Immigration Service about respecting sensitive locations and restricting enforcement actions in those sensitive locations like schools and houses of worship, that you need a high degree of authority from on high before doing enforcement actions. It appears that those memos are melting away in terms of stakeouts outside homeless shelters, outside of schools. Those are some of the stories we're beginning to hear. One positive note just today, it was either today or yesterday, the Fifth Circuit did issue a ruling on a harboring statute in the state of Texas that said that renting or providing a place to stay without more of an intent to actually hide someone does not constitute harboring. So we're going to see interesting things in terms of harboring. Fourthly, what about sanctuary jurisdictions and the charge to the new Attorney General to cut off funding? Well, there are two ways to look at this, and I've got 2 minutes, so I'm going to end with this point. One way is to look at jurisdictions as entanglement jurisdictions. So if you're interested in this topic, you can just search ILRC and entanglement, and you'll get this great map that really lays out the level of cooperation between local jurisdictions and immigration enforcement. And really looks at it from the opposite view of how much cooperation goes on between local law enforcement and immigration. One of the issues with what are being called Fourth Amendment jurisdictions, which some people call sanctuary jurisdictions, is that these jurisdictions, which include Hennepin County and Ramsey County, is that detainers that are issued by ICE, or Immigration and Customs Enforcement, to a sheriff to say, we want you to keep in custody this person who's in your jail. Those have been repeatedly been found to be violations of the Fourth Amendment requirement of probable cause before you put someone in jail or keep someone in prison. And so what the issue is often is the level of cooperation. And I'm going to run out of time here so quickly that I can answer questions about sort of the issues of sanctuary. I'm actually glad I'm out of time because the last thing I was going to talk about is something that's going to be on the exam that some of my students are going to be taking in an hour, and I can see some of them in the room. So I'm just not going to talk about those. It's been fascinating the last month. People come up to me and hug me, say, "How are you doing?" And I've got clients who've sent me emails saying, "How are you doing?" You know, and it's a little stressful, but you know, my mother called me yesterday and said, "I had a dream last night. You were trapped on top of a mountain of paper." And I'm going, all right, yeah, it's kind of stressful. But you know, over the weekend, I didn't have agents breaking down my front door and my back door and coming in. You know, so, all right, a little bit of stress, but not quite like that. We're supposed to talk to each other now?
Questions.
Excellent questions, and we'll try to get through as many of them as we can. But I just wanted to start off with giving any of the panelists who want to say something in direct response to each other's remarks the opportunity, if there are any.
Let's go to the audience.
No, let's go to the audience
Yeah.
questions.
Yeah.
Let's go to the audience.
Okay, so the first one is, first Professor Khan, but then to anyone. Is ISIS not real context for this executive order? Are they not responsible for brutal mass murders? Is ISIS not Islamic extremism? As far as I know, they've declared war in the West and have vowed to send fighters undercover as refugees into the U.S. Not to say the EO is perfect or even good, but I don't think talking about it makes sense unless we're viewing it as a response to Islamic terrorism.
A couple points about that. I think that yeah. I actually don't really buy the war on terror metaphor at all. I actually do think terror is an important consideration. I see it primarily as a law enforcement question. I certainly think you can make an argument that the armies and navies of Imperial Japan during the Second World War certainly had bad intent declared for us. It didn't justify what happened to 120 to 140 Japanese Americans. I don't see how anything that ISIS does can justify detaining a Muslim person simply because they're Muslim. And if I could just read a quote, can you hold that for a sec? Let's go find the quote. This is from Frank Wu, who wrote about, in the aftermath of 9/11, but even if there were 1,000 sleeper cells of Arab descent or Muslim faith ready to rise up in arms against democracy, they would constitute far less than a fraction of 1/10 of 1% of the Arab and Muslim populations in the United States. And that is something that would also apply to people trying to enter trying to enter the United States. And I'm not saying that ISIS isn't a problem or that I'm in love with ISIS. What I'm saying is that you actually have to go after people based on reasonable suspicion and individualized suspicion rather than stereotyping entire groups.
Let me take a quick stab, because if the question is, isn't ISIS a good reason for this order? The answer is no, and that's because the order doesn't claim it. And the lawyers in the cases didn't claim it. And in both the Washington case and the Virginia case on February 13th, the executive branch put on no evidence. No evidence was the court's holding. So so the next step would be, we can have discussions, and the president has a lot of power over national security and should have a lot of power there. But those aren't the claims that are being made as legal claims. They're overreaching and broader claims than that. If we backed up a little bit and got into the realm where we were in more of a true balancing test of what the president's authority is versus are these the right means, that's where the cases are going to land, and we might see some of that play out, I think, in the next order. We have not seen that in the cases so far.
On Friday, there was a leaked draft of a Department of Homeland Security Intelligence and Analysis Office memo.
Can everybody hear?
That said, DHS Intelligence and Analysis assesses that the country of citizenship is unlikely to be a reliable indicator of potential terrorist activity. So I don't want to be the victim of a terrorist attack. I don't want anyone else to be. But again, there needs to be a connection between what's proposed in the executive order and some factual basis.
Well, I have a related question, I think, to your last point, Virgil, from the audience. Sarah, did you? No. No, I think this was actually directed at Professors Nickel and Professor Berg, but it kind of picks up on what you're, I think, where you're going. Could you please gauge the legality of an executive order that would seek to limit the number of young males unaccompanied by women or children and give preference to women and children, much as is the current policy in Canada?
Virgil?
It's directed to you guys. You're the constitutional scholars. I'm just the flunky that.
Do the real work.
So, the always the punt answer is it depends. I mean, what kind of evidence do they have? What kind of evidence do they have of the difficulty of vetting, more specifically? But that's another extremely broad, rigid rule, and the fact that most terrorists are males, which I guess I assume that's true, is does not is not going to justify the over inclusion there. So I mean it will be interesting to see what comes out of the second executive order and any of the litigation on it, because as Virgil said, once you start talking about people who do not have some kind of resident status or some kind of admission to the United States already, then the arguments for the government's quote-unquote plenary power start to become more significant. And it was one of the many foul-ups by the Trump administration to write the order to apparently cover lawful permanent residents, people with green cards, and then not change it, just sort of say, well, okay, we won't apply it to them. But the precedents are stronger on this plenary power, and yet I still can't help but think that if a rule said we're not going to let any Muslim into the country, even if it's someone who's got no admission right already, that the courts would find a way to limit the plenary power doctrine. And probably the same thing I would think would be true with a blanket restriction on males. If you had talking about closer vetting of males, maybe that's a different question.
Any other thoughts about that?
Well, actually, I mean, I remember in the aftermath of the rollout of the executive order, there was some question as to whether the inclusion of lawful permanent residents was accidental or whether it was a deliberate result of pressure from Steve Bannon. So I think there are questions about including lawful permanent residents that make it a different question and make it a much more serious one and raise questions about motive.
Then I have a series of three of them that I think are actually related and might give any of you a chance to speculate a little bit, but let me give you all three of them. The first is maybe the most direct. Assuming the executive order is found to be unconstitutional, if the Trump administration does not follow the court's orders, what is the proper recourse? Then the second one, how does President Trump's relationship with the judiciary compare to Lincoln's? And is there historical evidence of a U.S. president issuing executive orders and having it play out in court as a way of doing business? Might we expect more of these executive orders from Trump? So I think these are sort of related invitations to speculate a little more broadly about presidents' interplay with.
I'll take one because that means I can punt on the other two and make somebody else take them. The first question on if President Trump doesn't follow them, I think the answer needs to be more specific. It's it depends answer, but it's not President Trump that is following or not. It's individual people. It's agents. It's an agency, and it's how it plays out. If I'm a judge and I've asked the attorneys and issued an order to do this, then what happens is if they still are enforcing it, and that case gets brought back to me in Washington, I ask the assistant U.S. attorney in front of me, bring me the evidence. This isn't happening, right? And I issue what's called a show cause order for why the Department of Homeland Security agents or Customs and Border Patrol are violating my order. And if they're continuing to violate the order, the U.S. Marshals are here with me as a judge, and I send the Marshals out, and I bring the Department of Homeland Security officials in, and I hold them in contempt of court until they obey my order. And the Marshals basically will do that because even though they're not Article III, they come through the executive branch, they're people of the court, right? They're going to be following a court order. And so the agents then will be in contempt of the court. Yeah, you're getting closer to a constitutional showdown, but that's, the agent might then say, well, the Secretary of Homeland Security told me to do it. Okay, I'm a federal judge. I'll hold the Secretary in contempt, and he can show up, and we'll have that conversation. But I think that's how this plays out.
So just to give an example, in the Texas v. U.S. case, a judge in Texas enjoined the government from implementing an expanded version of DACA that Sarah was talking about, as well as DAPA. And the government said by accident that we did, after the date of that order, we did issue several thousand new work permits that were for too long of a period of time. And they got seriously spanked by the judge for doing that. And then they went out and asked for all those work permits back. So that's just an example of, how this could play out. I don't remember what the other two questions.
Tom, do you want to talk about Lincoln?
More on that, or do you want
Talk about Lincoln.
Talk about Lincoln. Do a song.
So Abraham Lincoln rather famously opposed the Dred Scott decision and said Dred Scott was binding upon the parties to the case, but it was not binding upon other actors. Because we haven't turned over all our power to the justices on the Supreme Court of the United States. We can resist. The difference here would be that this would be the Trump administration as the party to the case resisting an order, and that's where so that that would be a step further than what Lincoln ever said. And Andrew Jackson, the earlier kind of the prototype of the populist president, said after one Supreme Court decision against the state that was rendered against the state of Georgia in the 1830s, he said, "Chief Justice John Marshall has rendered his decision. Now let him enforce it." But that wasn't a case, again, where the decision was against President Jackson. It would be quite a new thing for the president or his top aides to refuse to follow an order of the court, right? Even Richard Nixon had to resign because he was about to have to turn over the tapes. And I think if we got to that sort of stage of a direct presidential or high executive branch resistance to a direct order from the court, we'd be in new territory, and I think you'd even hear Republicans starting to talk about a constitutional crisis. So I hope it won't get to that.
Any other comments on that? Let me just ask, and I'll end with one that I think, maybe a short one. What entity determines the priority list for refugees? So moving beyond this particular question, whether or not these executive orders are upheld, who has the authority then to implement the priority lists in refugees?
Well, historically, the president once a year has set the number of refugees to be processed into the country. I think there's a suit going on saying that it can't be changed during the course of the year. I don't know how successful that will be. And then the Department of State, in consultation, I think with the Office of Refugee Resettlement and Department of Homeland Security, I think, they decide, okay, which of the 100,000, or is it 50,000 with Trump, or 120,000 with Obama, whatever the figure is, how many per continent are we going to aim for? And then within that, there's sort of an assessment of where are the refugees, where can we find them, and speak with them. And then there's also a priority usually placed on people with connections already in the United States. So there's a priority for people who have relatives here. So there's sort of a complicated kind of process that goes on.
Through the executive office.
Through the executive branch, yeah.
Well, ladies and gentlemen, please join me in thanking our five panelists. There's much more to be said about this, much more that we're going to be having to watch about this situation. But I think that you'll agree with me that we're all benefited immensely by better understanding what the basic legal ramifications and legal background of these orders are. So we thank you very much for your